War by Hypnotic Brass Ensemble. This is Democracy Now!, democracynow.org, The War and Peace Report. I'm Amy Goodman. Our guest in his first national broadcast interview is Nick Merrill. He has just gone public after being gagged for 6 years, having received a national security letter from the FBI, and the first to challenge it, to sue the U.S. government. Well, I also want to bring into this conversation someone else who was gagged by the FBI after receiving an NSL. George Christians, Executive Director of the Library Connection, a consortium of libraries in Connecticut. He joins us from Hartford. George Christian, welcome to Democracy Now! I'm sure as Nick spoke, it sounded familiar. Tell us what and when it happened to you.
It happened to us in 2005, and actually it was thankful that we're thankful that Nick made his protest. One of the problems is when the FBI comes, part of you says, well, it's the FBI, let's give them a hand. I had never heard the words national security letter before. I asked our attorney what a national security letter was. She had never heard the words before, but thankfully one of her assistants was able to do some research and find Nick's case and find that a judge had declared that the statute was unconstitutional because it violated the First, Fourth, and Fifth Amendments of the Constitution.
But George, could you step back a second? Could you step back a second and tell us,
yes,
when you were handed that national security letter, where were you? Who came to your door?
It was July of 2005, a year after Nick received his. The two FBI agents came to our office with the letter. They had called a week before and told us that they were going to serve us with a security letter. The thing that leaped to my attention about our letter was that it concerned an incident back in February, 5 months prior to this. It was dated in May, 2 months prior to July. And it was still addressed to the wrong person at our office, although they had called to ask who it should be addressed to. So I could conclude that it was not a case of hot pursuit, and that if I dug my heels in, we weren't jeopardizing any of our fellow citizens.
What did you say to the FBI agents who came to your door?
I said it was my understanding that a federal judge had ruled the statute authority they were using to be unconstitutional, and I would just like to talk with my lawyer. And the agent said, fine, wrote a number on the back of his business card and gave it to me. He said, have your attorney call this number, and they left.
And so you
It was only after I called.
You called a meeting of the executive committee of the Library Connection. And the Library Connection, what, is a consortium of the libraries of Connecticut, the internet system that you use? Yes,
we are owned by 26 libraries in the Hartford area, 27, one academic, 26 public. And our basic function is to provide IT services to these libraries. We run a common computer system for them so that they can share data amongst themselves, do interlibrary loans, share patron data.
So you decided to sue the government?
I decided that I was not going to participate in the violation of the Constitution, but I did want the approval of my, at least, executive board, because at that time I thought that a suit against the Attorney General of the United States might cost a lot of money, and I didn't feel I had the moral right to put their money at risk without some indication that they wanted to do this as well.
Because you were gagged.
But because we were gagged. But fortunately, they were on board as well, not only from constitutional point of view, but there's a long tradition. 48 of the 50 states have explicit statutes guaranteeing the sanctity of patron records and mandating that librarians take active measures to preserve the security of these records. So the federal law does trump state law, but they came from a long tradition of just saying no without a court order.
I don't know if most people think of librarians as the freedom fighters of our time, but here you four, the four librarians of Connecticut, took on the USA Patriot Act. This, just before this, at the time, Attorney General John Ashcroft, you sued Alberto Gonzales when he became Attorney General, had called librarians hysterical, said this wasn't happening to libraries. And yet, while you knew it was happening, you couldn't say it was happening.
Yes, that was extremely frustrating. The Patriot Act was up for renewal in Congress, and we at least wanted to go to Congress and tell them what had happened and ask them to redress this in the renewal. And I'm sure the gag order was maintained explicitly to prevent us from talking to Congress.
And so your case was joined with Nick Merrill's. You weren't even allowed in the first courtroom, is that right? When your case was being heard?
Yes, when we first sued the Attorney General, I told our attorneys I'd like to be in the courtroom. After all, I'm the plaintiff. And they said no. They had talked to the judge that would not be allowed because then our identity could be guessed. But the judge did allow us to go to a courtroom in Hartford, 60 miles away, where we were locked in a room with a security guard and able to watch our case on a monitor. But as the plaintiffs, we were not allowed in the courtroom.
Ultimately, your gag order was lifted.
Yes.
But what happened to your case?
Well, after the statute was renewed, it was modified significantly in the renewal, and the appellate court ruled that we had to go back to the initial court, the circuit court, and get a new ruling, but the judge there still said the statute was similar enough that she was lifting our gag order, and the FBI or the Justice Department informed our attorneys they would no longer oppose us in court, although they did try to convince the court to just drop the whole thing, but the court said nothing doing. They would allow the ruling to go ahead. So we had a judge declare our gag unconstitutional, and after that we were free to talk.
Nick Merrill, you too did not know who these librarians were, right? You knew them like you were known as John Doe.
Correct.
So what was it like going into court? You couldn't be identified.
Correct.
No one knew you were the person who was bringing this precedent-setting case.
Right. Like the librarians, I really wasn't able to go to court most of the time. There was one or two occasions in which I did go where they knew beforehand that there would be a huge crowd there. When I went to the Second Circuit, there were entire law school classes there, so there was just dozens of people, and it was standing room only. But I had been instructed that I couldn't talk to anyone. I shouldn't even say hello to anyone. I should just kind of keep my head down and listen if I like to, but just, be really quiet because, I was in danger of violating the gag. So.
George Christian, you watched the case from the Hartford courthouse when it was taking place in Bridgeport by closed-circuit TV because you were considered a national security threat, you and the three other Connecticut librarians, like, Peter Pace, head of the Plainfield Library?
Yes, Peter Chase.
Peter Chase, sorry.
We were considered, the release of our identity would be considered a national security threat because they reasoned then whoever they were interested in would realize that the FBI was closing in, although with 26 libraries, I doubt they could really make that a case. We did get to attend the appellate court along with Nick Merrill. We didn't know at that time whether Nick